What's the difference between receivership and bankruptcy? Hi, I'm Jane Muir and I'm a business lawyer here in Miami. Receivership is a state court process. Bankruptcy is a federal court process. When a receivership is imposed, a state court judge will decide basically to delegate their authority to a private person who will be the interim director of a company, kind of like an interim CEO. When a bankruptcy is filed in federal court, there are a list of approved federal trustees that will take that role in a similar way. But there are some kinds of bankruptcies where the debtor is the person in charge, but they're under court supervision. Another difference between receivership and bankruptcy is the purpose. A receivership's purpose is to either maintain a business during a fight between its owners or against a creditor who has a major judgment against the company. On the other hand, bankruptcy is implemented by the debtor so that they can get rid of all their debts at the same time and kind of consolidate and get into a repayment plan. In a receivership, there's no pause on a litigation, but in bankruptcy there is, and it stops all litigation in an automatic stay. In a receivership, it can be limited to just reporting and not operating the company. In a bankruptcy, it's a comprehensive process that includes all the assets and operations of a company. In a receivership, the objective is achieved when either the company is wound up and all the assets are sold, or the litigation is resolved. Bankruptcy, on the other hand, ends with a payment plan that is approved by the court. The key takeaway here is that receivership is a court-supervised management practice versus bankruptcy that's a court-supervised repayment of debt.